We're now live in the practice information session, and this video session is being recorded. I'm joined today by Julie Breen and Moila Brady Bates from Arthur Cox to discuss dignity matters, bullying and sexual harassment in the workplace. So prevention is better than cure. So we'll be getting started at 1 o'clock, so you're all very welcome. So hi Julie, hi Moila.
Hi Justin.
Hi Justin.
Looking forward to this conversation today. Short and sweet. I think there's so much to cover, so it will be. We were just saying it will be hard to fit everything in, but we'll try to get around to everything.
Yeah, I'm really looking forward to just hearing the sort of practical steps that we might hear about with regards to how to perhaps, I think, deal with this matter is probably a bit too intense, but like how we might manage the situation in our offices to the best of our ability.
Yeah.
So it's just coming up to 1 minute. We'll get started at 1 o'clock sharp. So thanks everyone for joining us today.
Everybody's back to work as well. I mean, so a lot of people are back in the office, so it's a kind of a different working environment now for everybody.
There's a lot of traffic on the road. Yeah,
can find the space at work to. I'm not sure if people are in open plan offices or, you know, if they've got their own offices, they can take the time to watch this during lunchtime. I think it's sometimes always easier to do these things at home.
I think you're right, Julie. Yeah.
So it's just gone 1 o'clock, so we'll get started because I know we have limited time. So you're all very welcome to this practice support information session, bullying, harassment and sexual harassment. And today we're going to be discussing, as part of the Dignity Matters report, prevention is better than cure. So I'm joined by Moila Brady Bates, who is a senior associate specializing in employment law with Arthur Cox, and Julie Breen, who's the professional wellbeing executive at the Law Society. So the session will be recorded. We'll send it out at the end of the week, and also the previous sessions are available on the Law Society YouTube channel. So you're all very welcome. If you'd like to ask a question, we'll take it on the chat. So over to you, Julie.
Thank you very much, Justin. Really looking forward to talking to Moila today. So just to give you a bit of a bit more understanding about what Moila does. Moila is a senior associate specializing in employment law with Arthur Cox. Moila works across all aspects of employment law, including both contentious and non-contentious matters. And she's taken a keen interest in public interest work and has been working closely with the Dublin Rape Crisis Centre on matters of workplace sexual harassment in most recent years. So last year, together with the Dublin Rape Crisis Centre, Moila co-authored a discussion paper on workplace sexual harassment and abuse. So today we are the second in the Dignity Matters series, information session series. This series is really responding to the recommendations of the Dignity Matters report to raise awareness and normalise the conversation about harmful behaviours like bullying, harassment and sexual harassment in the workplace. Furthermore, the recommendation to introduce regular and customised trainings relevant to the profession and to increase dialogue and best practice sharing for individuals and firms on dignity at work issues. So that's just a kind of, you know, to give us some context for the conversation today. Moila, I'll hand it over to you. I know you've given this a lot of thought. Prevention is better than the cure. That's what the title of today is. So yeah, we look forward to hearing from you.
Thank you very much, Julie, and good afternoon, everyone. As Julie mentioned, my name is Moila Brady Bates, and this is the second information session being run by the Law Society as part of this series. So just to note that last week's session covered the law and what employers need to know. And so if you haven't had a chance already, I would encourage you to watch that session back as it sets the legal landscape for today's discussion. So as Julie mentioned, today's topic is bullying, harassment and sexual harassment. Prevention is better than cure. And so today I'll be focusing on two aspects. First, the best practices to foster positive and healthy workplace cultures. And second, providing practical tips to employers to help prevent workplace bullying, harassment and sexual harassment. But before I delve into today's topic, however, I would like to recap briefly on some of the fundamental legal concepts and definitions underpinning bullying, harassment and sexual harassment in Ireland. And I should say before I go on, I'll probably use the term harassment and sexual harassment interchangeably, but when I say harassment, I do mean sexual harassment as well. So I'm conscious that these were covered in depth in the previous information session, so I won't dwell on this for too long, but I do think it's important to touch on this briefly in order to frame today's discussion. So what does bullying, harassment, and sexual harassment mean, and what's the difference between these concepts? The primary legislation that applies in this area is the Employment Equality Acts and the Safety, Health and Welfare at Work Act. And the Employment Equality Acts prevent harassment in the workplace, while the Safety, Health and Welfare at Work Act obliges employers to prevent any improper conduct or behaviour likely to put the safety, health and welfare and welfare of employees at risk. So even though the terms bullying and harassment are often used interchangeably, the law makes a clear distinction between them. So whereas harassment is an act that subjects a person to unwanted conduct on any of the 9 protected discriminatory grounds, for example, sexual harassment, religious harassment, or racial harassment, the Employment Equality Acts do not apply to a generalised bullying situation, which has no link to these discriminatory grounds. And furthermore, the definition of bullying refers to repeated inappropriate behaviour and specifically excludes a single event. So there's no similar requirement, interestingly, in the definition of harassment or sexual harassment under the Employment Equality Acts, and therefore a single complaint of harassment or sexual harassment can breach the Acts. So let's just briefly take a closer look at the definitions for bullying and harassment. In January last year, a new code of practice on the prevention and resolution of bullying at work was jointly published by the Health and Safety Authority and the Workplace Relations Commission. The new code streamlines the previous codes of practice on bullying and provides guidance for employers and employees on good practice and procedures for addressing and resolving issues of workplace bullying. And the code retains the definition of bullying contained in previous codes, which is repeated, inappropriate behaviour, direct or indirect, whether verbal, physical, or otherwise, conducted by one or more persons against another or others at the place of work or in the course of employment, which could be reasonably regarded as undermining the individual's right to dignity at work. And so this definition should be read in line with the recent Supreme Court decision in Roughly versus the Board of Management of St. Anne's School. In that decision, the Supreme Court overturned the decision of the High Court, which resulted in the highest amount ever awarded in a bullying claim and an apparent broadening of the definition of bullying. So in its decision, the Supreme Court distinguished between classic bullying and a breach of fair procedures. Significantly, the court found that Ms. Roughly's treatment during the disciplinary process did not constitute an intention to destroy her dignity at work. And so it held that while the disciplinary process was no doubt defective, a breach of fair procedures does not, in and of itself, constitute bullying. So I think that's a very important case to bear in mind when we're looking at the definition of bullying, because all 4 elements must exist for behaviour to be considered bullying. It must be repeated, inappropriate, workplace connected, and reasonably regarded as undermining the individual's right to dignity at work. The code elaborates on these elements, describing bullying in terms of seriously negative, targeted behaviours, which must undermine their esteem and standing in a harmful, sustained way. It requires bullying to be clearly wrong, undermining, and humiliating.
Thanks, Malia. I was thinking when you were speaking there about how subjective it can be, somebody's experience of bullying, harassment, or sexual harassment. So, I may perceive something as bullying and somebody else may not perceive it as bullying. And I think often the bully doesn't know perhaps if they're bullying, that might be the case. Does the code offer any guidance on what is not bullying to kind of help employers and employees understand that a bit better?
Yes, it's a really good question, Julie. And actually the code, I think, it's a really good port of call for employers and employees because it's really user-friendly and really clear and direct. And while I suppose that there's a distinction between bullying and harassment in the sense that bullying is an objective test and harassment is more subjective, as you say, it can often be hard for people to understand themselves that their behavior is actually bullying or someone might perceive something as bullying when it's not. And so the code does provide clarity on what is not bullying and lists a number of examples, such as offering constructive feedback, strongly expressing differences of opinion or ordinary performance management. And it notes also that while disrespectful behaviour and conflicts and relationship breakdowns are not ideal in the workplace, they don't automatically reach the adequate level of destructiveness to be considered bullying.
Okay.
So that leads us nicely on to the contrast with the concept of harassment and sexual harassment. because, as I said, there's an objective test in bullying and a subjective test in harassment. And like bullying, earlier this year, a new code was published by the Human Rights and Equality Commission on the area of sexual harassment and harassment at work. And this was very welcome because the previous code of practice was published in 2012. So an updated code was badly needed. So just to discuss the definition of harassment and sexual harassment, under the Employment Equality Act, sexual harassment and harassment of an employee, including agency workers and trainees in the workplace, are against the law. And this includes harassment by co-workers, the employer, clients, customers, and other business contacts of the employer, including anyone the employer could reasonably expect the worker to come into contact with. So it's a very broad scope in that definition. The Employment Equality Acts define harassment as unwanted conduct which is related to any of the 9 discriminatory grounds, and sexual harassment is any form of unwanted verbal, non-verbal, or physical conduct of a sexual nature. So in both cases, it is defined as a conduct which has the purpose or effect of violating a person's dignity and creating an intimidating, hostile, degrading, humiliating, or offensive environment for the person. So as I mentioned, in contrast to the definition of workplace bullying, the behaviour does not need to be repetitive to constitute harassment, and also it's subjective. So it focuses on the inevitably personal response of the individual to the conduct which they've been subjected, without any limitations of perceived reasonableness. So in that sense, it doesn't matter whether the intent behind the behaviour was to violate the person's dignity, etc. It is the manner in which the recipient perceives the behaviour which is essential to the definition. And the Labour Court has confirmed this in its adjudications. Otherwise, the new code remains substantively the same as the previous code in 2012, but the most important changes in the code reflect what we would already consider to be best practice by employers in this area. And the code aims to give practical guidance to employers, organisations, trade unions, and employees on what is meant by employment-related sexual harassment and harassment, how it can be prevented, and what steps ensure that adequate procedures are readily available to deal with the problem and to prevent reoccurrence. I suppose it's important to note that while the codes provide useful guidance to employers and they are admissible as evidence in hearings, they do not constitute an authoritative statement on the law, and they don't impose any legal obligations in and of themselves. But they are very user-friendly, and I would encourage everyone to go and have a look at them. So now that we've set the legal scene, let's look at the best practices to foster positive and healthy workplace cultures, to help prevention, and also the best means for employers to deal with issues as they arise, to effectively resolve them, and also to prevent reoccurrence. So prevention certainly is better than a cure. This principle underpins both the codes by placing an obligation on the employer to establish positive workplace environments free from bullying, intimidation, harassment, and ongoing negative behaviour. It is a defence for an employer to prove that it took reasonably practical steps to prevent and reverse any effects of the behaviour. However, in order to rely on this defence, employers must have a comprehensive, accessible, and effective policy in place that focuses on prevention, best practice, and remedial action. And there must also be a strong commitment to implementing the policy, as well as an accessible complaints procedure. The purpose of a policy is not simply to prevent unlawful behaviour, but to encourage best practice and a safe and harmonious workplace where such behaviour is unlikely to occur. So a policy will be effective if linked to a broader equality policy, and it's common practice for employers to have an overarching dignity at work policy which deals with equality, discrimination, harassment, and bullying. The policy and complaints procedure should be implemented insofar as possible with clients, customers, and other business contacts after consultation with trade union or employee representatives where appropriate. The policy should be communicated to all employees and to all levels of management. Key to an effective policy is ensuring a culture of commitment to the values underpinning the policy across all strata of the organisation, and both codes identify the role of the organisational culture as a key player in prevention. There is an emphasis on the importance of fostering a supportive workplace culture with zero tolerance for bullying and harassment. And good leadership, proper communication, and staff training, and the resolution of complaints in a supportive, effective, and fair manner are all aspects of a positive organisational culture. Strategies to create and maintain a working environment in which the dignity of employees is respected are most effective when jointly agreed, and employers, employees, and other interested parties, such as clients and suppliers of goods and services, can work together to create a culture of respect in the workplace. With regard to harassment in particular, the subjective nature of the manner in which a statement or action may be perceived should be communicated to all policy subjects. And training regarding the core principles of the policy and the sensitivities of fellow workers should be implemented across all strata of the organisation, and its effectiveness should be monitored on an ongoing basis. So in this regard, a policy should state that management and others in positions of authority have a particular responsibility to ensure that harassment and bullying does not occur, and that complaints are addressed promptly and swiftly and effectively, and that employees must respect the dignity of others in the workplace.
Yeah, I suppose I'm just thinking, and when you were speaking there, Malia, about role modeling and leadership, really good leadership in with regards to this, and communication, as you were saying. We were doing something recently. We were creating a video, actually a Dignity Matters video, and one of the quotes from that was "Behavior is contagious," and setting, we all need to set standards, but in particular, leadership needs to set standards. And also that bad behavior needs to be held to account. And I, when you were speaking there, I was thinking about how consistency in how complaints are treated for everybody in the workplace, no matter how, high up in the organization they are, or how, whatever position they hold, that there's consistency for it. What are the core elements, do you think, to ensure policy is effective? Because a lot of organizations have policies, but it's not working, it's not preventing this behavior from taking place.
Yeah, I completely agree. And I think you're right about making sure that that it applies to all strata of the organization is really important. And it's true that a lot of organizations would have policies, and for some reason they're not effective or they're not properly implemented. And I would probably just go back again to the codes and direct people to the practical guidance in the codes, because they set out the key elements that should be included in a dignity at work policy, and they're set out in a very accessible way. So I suppose I won't delve into them in detail because I'm conscious of time, but I might highlight a few key principles that the codes mention that should underpin an effective policy. And I suppose most importantly, it's a policy can only be as useful as its implementation, as you say, Julie. So it's all very well having, great best practice policy, but if it's not being followed for whatever reasons, then it's not going to be effective. So the first thing, I suppose, would be to look at the policy to make sure it's written in a clear, direct and accessible manner that will be accessible to all members of staff, regardless of their abilities. And then in order to ensure that once you have the shiny document and it's all well set out, to ensure that it's adhered to and it reflects workplace culture, I suppose, training should be provided to ensure that all policy subjects understand the policy, and that there aren't any kind of understanding gaps, and regular monitoring of that should be carried out to see if there are gaps in the policy itself or there are gaps in how it is being implemented. And I suppose the key to that is the why. If there are gaps, why are there gaps and what can we do to address them? And one of the new additions to the code on harassment is that it now gives practical examples of how to monitor policies regularly. So, for example, by way of staff surveys or anonymized questionnaires or confidential discussions at training courses, etc. So there's some useful, as I say, practical tips in the codes that might prompt employers to reflect on what they're doing themselves in terms of how they're implementing their policies. Sorry, go ahead, Julie.
Yeah, I'm wondering about what trainings you have seen work well in organizations, or if you can, if there's any kind of recommendations around that.
Yeah, I mean, I think aside from your classic training on the policy and explaining what bullying is and explaining what harassment is and kind of workplace values of equality, etc., I think some other trainings that people may not necessarily link to kind of being effective for the dignity at work policy is things like sensitivity training or even unconscious bias training, particularly where you have this subjective aspect to workplace harassment. So and indeed, linking in with our discussion about bullying a few moments ago, while there isn't the subjective element to the definition, it's certainly true that someone might perceive constructive feedback as a bullying situation. So I think first and foremost, training on the policies, explaining to people what bullying and harassment is and making sure the policies are fully understood by staff. But then secondly, having training around sensitivity training, unconscious bias training, in order for people to understand and have a bit of self-awareness that their actions, while they may not perceive them as harassment or offensive, may have that effect on somebody else and may be received like that. And that's something just to be really aware of. The classic example is, workplace banter. It was just a bit of banter, but so I think those kind of trainings can be really useful in tackling that.
Yeah,
and can be very effective.
Yeah, there's something about, looking at yourself and potentially, trainings where you can see yourself, your tone of voice, your body language. It's not always, there's a self, it requires us to have some form of a really high self-awareness actually to understand sometimes how that might be impacting an individual. And so, yeah, including those kind of ideas into the training, for example, and what's the word I'm looking for? It's role plays. So
yes, yeah,
that type of thing was really helpful.
Right. The key, self-awareness is key, and I think that feeds into all kind of diversity and inclusion kind of matters, I suppose, because people without the self-awareness, you don't realize that you might hold these biases, or that you are being exclusatory, or that you just haven't, because you haven't exposed yourself to various different types of settings, you may not be aware of certain things that might cause offense to other people. So yeah, I think they can be really effective. And one thing as well that also can be really effective and that's highlighted in the codes is the idea of having a senior person outside the structure of HR. So in the case of harassment, it's a champion, or in the case of bullying, it's called a contact person. But they're kind of someone that can champion those values, can kind of keep a watchful eye over whether the policy values are being kind of followed and implemented. And also they're someone that you can go to if you have any concerns at all. So it's kind of another safety net for organizations, I think. And if the organization has the resources and the capacity to have that, it could be very useful. But the codes do flag that, it's really up to each organization to depend what they're able to have in that respect, depending on their resources and their size.
Yeah, I'm sure for individuals in the organization, if you have been affected by any of these matters, having somebody who you feel is quite passionate about this, is trustworthy, that you can go to and have a conversation about it. Just knowing that there's an individual in your organization that cares.
Yes. Yeah, and I think the key to that as well is that they're an independent voice, so they sit outside the kind of traditional structures that you may be afraid to approach, or, you might be fear of, I don't know, you might have some fears around talking to management or HR for whatever reasons. And so if they can be an independent voice, then that can be really beneficial.
Yeah. I'm conscious, Molly, that we're kind of coming to time, but I thought I'd just ask you, I know you had, we had talked about maybe going into complaints procedure, but I think we might be touching on that. Well, I know we will be touching on that next week with our speakers. So we probably don't need to go into kind of full kind of detail on that.
Sure.
But I suppose I just thought I'd ask you one last question. I was wondering, in your experience of doing this type of work with employers, what would you say is the difference between a company or an organization with a really positive workplace culture and a company with a negative workplace culture? What can we learn from the companies that do this really well? What are they doing really well?
Yeah, I think it's a really, really good question, because it seems to be something, it seems quite intangible for people to kind of grasp. Well, what is it? And I think when I was reflecting about this talk this afternoon, I think one of the key factors is this piece of self-awareness. So it's not being afraid to look internally. So I think that it's kind of, I suppose in some respects it's twofold. There's often either a reluctance to kind of admit that there may be a problem, so there feels a bit of shame and stigma, like the organization is failing. If they acknowledge that and if they kind of take steps to address it, there can be that kind of stigma. Or there's just a general ignorance. We don't have issues like this in the workplace, so why would we need to address them? And I think both of those are dangerous and can then bleed into having more of a negative workplace culture, because without acknowledging that there may be an issue, then you're not going to foster, open communication around issues. You're not going to encourage reporting, and you're certainly not going to take the steps that you might need to identify the gaps that you have, because you don't know what the gaps are in the first place, if that makes sense. So I think those two are, to me, fundamental to fostering kind of an open and positive workplace, because they would lead then to identifying the gaps and taking steps to address them in a kind of, I suppose, without shame or without judgment, just acknowledging that this is part and parcel of life and of work. And so, they're even with the best and most positive workplace cultures, there inevitably will be cases that arise. So no one's immune. So taking that step is really important to identify the gaps, but also not sticking your head in the sand, I think, means that other people will feel like they can come forward and give constructive feedback, or say, look, I have an issue here with this person. And it's way more open and encouraging of communication, I think.
Yeah, and I think recognizing that reporting is good.
Exactly.
Like, you want to see reporting. I think some organizations say, well, no, we don't have a problem because, nothing's come up.
Exactly.
But actually that's maybe a kind of short-sighted view of things, especially in the context and the environment, the social climate that we live in at the moment. This is a really hot topic, and society is changing. Our perceptions are changing around what's acceptable and not acceptable. So being careful about that. Just because you don't have reports coming in, it's not because it isn't happening. It may be because the reporting system is
flawed in some way, or completely agree. And I think that's really what I mean by kind of assuming you don't have a problem because you it hasn't come to your attention is a surefire way, I suppose, to stick your head in the sand about the issue. And if you do encourage reporting, and if you do have open and frank conversations about what the workplace values are and what will and won't be tolerated, and encourage people to do the same with you, then you'll get a far greater snapshot of what's going on with your organization and how to address issues people are having.
Yeah. I suppose the word that's coming into my head is acceptance that it does happen. Where it's the workplaces are relational.
Exactly.
So these things are going to happen. So, there's no point in suggesting that your firm is kind of super has superpowers or superhuman. And
exactly. This kind of idea of perfection, I think this exactly. And that, I think, as I said, even with fostering the best culture in the world, as you say, they are relational. And when people come together, and, issues unfortunately inevitably arise for whatever reasons they do. And so if you think you don't have a problem, that's just not going to be the case.
Maybe that's a good sign that you should do a bit more research and do some investigation.
Exactly.
Brilliant. I think we have captured all the questions in the chat. I think there was 2 questions there around let me see. Trainings on dignity at work issues, and then would be super clear an example of an activity sector organization that models healthy cultures at work. And I think you kind of talked through that, Malia. So thank you very much. Really, really appreciate that conversation. Again, it was very short, and I'm sure we could speak for another hour on prevention, but we will be developing a Dignity Matters toolkit. And all of this information will be up on that toolkit. So this information isn't lost. First of all, we have the recording, but we will also have a Dignity Matters toolkit that will be coming out in the next couple of months. So all of this information around the law and prevention is better than the cure, and also how to, what happens when you're, how do we intervene when there is a complaint. And just to say that we also have Legal Mind. If anybody on this call has been affected or knows somebody who's been affected by bullying, harassment, or sexual harassment, it can have effects on people's mental health. So Legal Mind is a support, an independent and confidential, low-cost support available to solicitors and their dependents, and final year trainees of the law school as well. It's available 24/7, and the phone numbers and text message number is there for all of you to see if there's anybody that needs to call that. Thank you. I'll hand over to you now, Justin.
Yeah, thanks, Julie, and thanks, Moya, for a very interesting and informative presentation. We're just running out of time now, so I suppose I'll just talk about next week's the the final bullying, harassment, sexual harassment is intervention once a complaint is raised. And then the following week, on the 1st of June, we're talking about cessations, closing down or winding up a practice. And then we're going to take a week off for the bank holiday and then learn about TrialView, a digital dispute resolution service via the cloud on the 15th of June. So we look forward to talking to you in the future. As I said earlier, we'll send out a recording on Friday to everyone who attended, and they're available on the Law Society YouTube channel. So my name is Justin Purcell. I'm the Law Society Practice Support Executive. So if you'd like to email me with any queries you have, happy to take them. So again, many thanks to Julie Breen and to Moila Brady Bates for joining us today. Sloan, August Garamogat.
Bye, everybody.
Thank
Thank
you
you
very much.
Thanks, guys.
Bye.
Bye.